Hi, everyone. Good morning. We'll just give people another minute or so to kind of pop online since we just hit the 9 o'clock hour. But I won't wait too long because we want to get started and keep things on time for you. So we'll give them one more minute and then we will get started. Okay, good morning and welcome to the Ontario. Oh, you know what? Sorry guys, I should have done this during our practice session. I need to switch my camera. 1 second so I can actually see my notes as we go along. There we go. Screen. My apologies for this. And the best part is we actually tried to get things set up originally before everybody arrived. Give me 1 second. Yes. And of course, I'm able to do this before this gets started. Okay, let's just do it this way. There we go. Dylan, is that working now? Can you see the slideshow?
Yep.
Okay, thank you. Sorry about the delay, everybody. You'd think after this long on these virtual presentations, I would be a bit better with it. So my apologies. So let's start again. Good morning and welcome to the Ontario Not-for-Profit Corporations Act, a blueprint to ensure compliance. I promise to do my best to make a legal topic as riveting as possible. My name is Alysia Christiaen. I'm a partner at Lerners. I practice corporate law, working with both for-profit and nonprofit corporations. As you can imagine, a lot of the work that I'm doing right now with my nonprofit clients is helping to bring themselves into compliance with the new Ontario Not-for-Profit Corporations Act, or ONCA. Today's presentation is meant to be for information purposes only and is not to be considered legal advice. Throughout my presentation, if you have any questions, please feel free to enter them into the question box as we go along. And then Dylan will let me know when questions come in so that we can talk about the question as they come up instead of waiting to the end. We should still have a bit of time to deal with any final questions that you might have, but please feel free to, I'm happy to interrupt the presentation as we're going along to answer your questions. So today we will be covering the major changes in the legislation that nonprofits should be mindful of when determining whether their bylaws and letters patent or articles of incorporation need to be revised in order to comply with ONCA. ONCA was actually passed in 2010, but did not come into effect until October 19, 2021. Nonprofits had 3 years or until October 19, 2024 to comply with the Act's requirements. You need to be in compliance by October 19 of this year, so in exactly 4 months to the date. If a nonprofit does not comply with ONCA by the deadline, it will be deemed to comply. Your nonprofit isn't going to be dissolved if you're not in compliance. So you may be asking yourself, why should we go through this transition process if we're just going to be deemed to comply in several months anyway? If you don't, it'll be extremely confusing for your directors and any staff that you may have. Your articles and your bylaws would not be the source of your governance rules, but instead you'd have to read the legislation, which is rarely written so as to be easily understood. To provide some additional comfort, there are no ONCA police out there. However, going through an ONCA compliance review allows your organization to revisit your governance structure and processes, which may not be accurately reflected in your current bylaws. It's surprising how many of my clients are not conducting their governance in accordance with their own rules. It's very easy for this to happen in organizations with boards comprised of volunteers who don't have a director with corporate governance experience. Depending on how old your nonprofit is, it may have been created by filing letter patents with the Ontario government in order to be incorporated. The letter patents are now called the Articles of Incorporation under ONCA. If changes were needed to the letters patent, then supplementary letters patent were filed. Now under ONCA, Articles of Amendment are to be filed. Some of your organizations may need to file articles of amendment as part of your ONCA transition, depending on the changes that are made to your governing documents. The articles of incorporation or letters patent contain the purposes of the nonprofit, its address, the number of directors you have, the classes or groups of members, and the rights of those members, and other special rules. Bylaws are like the constitution of the nonprofit. They contain the governing rules. It's how you will carry out the business of your nonprofit. This is where the procedures for decision-making for the nonprofit are found. Your policies are the operational documents of the nonprofit. These may include human resources policies or a code of conduct for members. ONCA does not contain any requirements for your operational policies. It deals solely with corporate governance. Members are the people who have governance power, like electing the directors and appointing the auditor. In many nonprofits, there is a closed membership, which means the only members are the directors of the organization. You'll need to look at your bylaws to determine who can be the members of your nonprofit. Your bylaws will set out any membership criteria or qualifications. Your nonprofit must have a members register that lists its members. Directors are the people elected by the members to oversee the management of the nonprofit. Under ONCA, a director does not have to be a member of the nonprofit, but it's very common to make that one of the qualifications to be a director. Officers are appointed by the directors for specific jobs, like president, secretary, or treasurer. It's possible that one person could be all of a member, a director, and an officer of the nonprofit. So it's possible that one single person will wear 3 different hats with regards to the nonprofit. They could be a member, They could be then a director if they're elected to the board. And then while a director on the board, they may be appointed to hold office. Under ONCA, there is a new category of nonprofit called the Public Benefit Corporation. It's a special type of nonprofit corporation. To be a public benefit corporation, your organization is either a charitable corporation, meaning the organization has charitable purposes. It doesn't matter if it's been designated as a registered charity by the CRA, or the nonprofit is a non-charitable corporation that receives more than $10,000 in donations, gifts, or grants from non-members in any financial year. When you become a public benefit corporation is determined by your previous year's finances. So if in 2023 you received more than $10,000 from non-members, then in 2024 the organization is a public benefit corporation. A public benefit corporation status assessment should be done yearly. It is possible to be a public benefit corporation one year and then the next not be one. It all depends on the sources of your funding for the previous fiscal year. So if you think that you could move back and forth between being a public benefit corporation or not, it will be easier for you if you just operate as a public benefit corporation, because there are restrictions that apply only to public benefit corporations. I've been asked by a client before if a sponsorship from a non-member that is in excess of $10,000 would make a nonprofit a public benefit corporation. The government hasn't provided any guidance on this yet. In my opinion, it wouldn't become a public benefit corporation for a sponsorship in excess of $10,000. A sponsor is paying to have the right for its name and logo to be promoted by the nonprofit. So it's getting something in exchange for that $10,000 sponsorship. However, as noted, there isn't any direction yet from the government. So I would recommend that you defer to the opinion of your auditor or accountant if you are a nonprofit that has sponsorships coming in excess of $10,000. So as mentioned, there are special rules or restrictions that apply to a public benefit corporation. The first has to do with the number of directors on the board. A maximum of 1/3 of the directors can be an employee of the corporation if your nonprofit is a public benefit corporation. Another restriction has to do with asset distribution on dissolution of the corporation. In the event that a public benefit corporation dissolves or shuts down, then the assets have to be distributed in compliance with the ONCA requirement. For a non-charitable public benefit corporation, the net assets are to be distributed to a public benefit corporation with similar purposes, to a Canadian registered charity with similar purposes, or to one of the 3 levels of government. A restriction that can result in additional costs for the public benefit corporation is that there are higher thresholds to meet to be able to avoid having an audit or a review engagement completed for the nonprofit's financial statements. We'll talk about that next. So under ONCA, members are required to appoint by ordinary resolution, which is a majority vote, an auditor or person to conduct a review engagement at each annual meeting. So the chart on the slide sets out the exemptions to that default rule of an audit or a review engagement. So if annual revenue is less than $100,000, then the nonprofit does not have to complete either an audit or a review engagement if the members pass such an extraordinary resolution, which is an approving vote of at least 80% of the votes at a members' meeting. This exemption applies regardless of your organization's status as a public benefit corporation. So if annual revenue is between $100,000 and a penny less than $500,000, if the nonprofit is a public benefit corporation, the members can decide to have a review engagement. If the nonprofit is not a public benefit corporation, then the members can choose to have neither an audit or a review engagement completed, again, provided there is an extraordinary resolution passed. Finally, if annual revenue is more than 500,000, if the nonprofit is a public benefit corporation, it has to have an audit. If the nonprofit is not a public benefit corporation, then the members can choose or vote by extraordinary resolution to have a review engagement instead of an audit. So an audit is an in-depth review of the nonprofit's finances, and the auditor will provide an opinion and reasonable assurance as to the nonprofit's financial position. A review engagement is a review of the nonprofit's finances, and the assessor will confirm simply that they are plausible. It's a much less in-depth review of the finances and therefore less expensive, but it does not provide the same level of assurance as to the accuracy of the financial statements. So there's a number of changes relative to board directors in ONCA. A director's term cannot exceed 4 years, but there is no cap on how many times a director can be reelected, essentially ignoring whether it's a good idea for an organization to have a director serve for as long as the members continue, or that to have an indefinite director on the board. It is possible under ONCA for a director to serve for as long as the members continue to elect them. Terms of the directors can be staggered, which provides that there are always directors on the board with experience. Some boards have a director who holds the position by virtue of another role that they have. That director is an ex officio director. So for example, if your nonprofit is associated with another organization, it could have a representative from that organization on the board by default. The members would not vote for an ex officio director. They're a director of the board because the bylaws state that they are. Whether an ex officio director has voting rights should be set out in your bylaws. Once a person is elected as a director of the board of the nonprofit, they are to sign a consent to act as a director within 10 days of being elected or appointed, as the case may be. So this may be something that your nonprofit needs to make sure that they have. Some of my clients have never had directors sign a consent. So just be mindful, check your corporate records if there are signed consents, and if not, then that's something that you'll want to get your current directors to do, as well as any newly elected directors this year. The board of directors is to choose a chair of the board from amongst themselves. Often nonprofits do not have a chair, they only have a president. Under ONCA, a chair must be appointed. The chair can be the same director that is the president, as directors can hold more than one office. So the chair is actually the only officer that ONCA requires you to appoint. It doesn't require a president, it doesn't require a secretary, even though these are very common officer positions that nonprofits and for-profit corporations have. All that ONCA requires is for a nonprofit to have a chair. And again, as mentioned, if this is something that your nonprofit doesn't currently have, you can make it, you can write your bylaw so that the president will hold the office of chair. As mentioned, one individual can hold more than one office. Except you cannot have a president also hold the office of vice president. Directors do not need to be a member of the nonprofit corporation. However, the bylaws can require that as a qualification of being a director. Many nonprofits do have that, as mentioned. Unless the bylaws provide otherwise, directors and officers can be paid for acting in this capacity for the nonprofit. However, this does not apply to a registered charity. And in all honesty, most of my nonprofit clients have it that the directors are not paid or remunerated for their service as a director. Directors, officers, and members are also able, under ONCA, to be paid for any services performed for the nonprofit corporation in another capacity. For example, if you had a web designer on your board as a director and they redesigned your nonprofit's website, that director could be paid for their design work. Please note, that if your organization is a registered charity, then there are some restrictions on being able to pay directors for services provided other than acting as a director, but it is permitted. There's just some additional rules that you have to follow if you're a registered charity. Under the old legislation, nonprofits had to have a fixed number of directors on the board. Under ONCA, a nonprofit can have a minimum and a maximum number of directors. The minimum required is 3, and there's no limit on what the maximum is. Although having a board with too many directors can sometimes be hazardous and ineffective. There's just too many cooks in the kitchen, as they say. I often recommend to clients to consider having a range for their number of directors. It allows the organization to be able to bring a star candidate immediately onto the board. It also means that a vacancy does not have to be filled immediately if there's a resignation without a good replacement identified. If a nonprofit wants to be able to take advantage of the flexibility of having a range of directors, then your articles of amendment will have to be filed. And the number of directors is something that has to be approved by your members. So you would need to present the members with both the new bylaws to be approved, as well as that provision of the article of amendment. So during the pandemic, the provincial government passed emergency legislation that allowed corporations, including nonprofits, to conduct board and member meetings electronically. The government has amended ONCA so that by default, a nonprofit can hold meetings of the board and of the members via phone or on a virtual platform, or as a hybrid between in-person or electronically. If the nonprofit wants to have only in-person meetings or to limit the number of electronic meetings held, then it can do so in the bylaws. But as mentioned, the default is that the organization can have every meeting electronically if they so chose. Note that there are different criteria for being able to conduct a board meeting or a member meeting electronically. For a board meeting, attendees have to be able to communicate with each other simultaneously and instantaneously. So for example, a Zoom meeting where everyone is able to speak at the same time and participants control their own microphones would be an example of being able to speak simultaneously and instantaneously. For members' meetings, attendees only have to be able to reasonably participate in the meeting. In this case, attendees that are participating electronically may be muted by the host and then unmuted when they have a question or want to make a comment. So a bit of a different test for how to conduct electronic meetings for the board versus members to keep in mind. When providing a notice of an electronic or hybrid meeting, it must include instructions for attending and participating in the meeting. So the meeting link has to be given and instructions on how to vote, if it will be through a method other than saying your vote verbally or a show of hands, would also need to be included in your notice of an electronic meeting. The ONCA provides for alternative methods of voting at a members meeting. Proxies are only permitted if the bylaws provide for them. So if you currently have proxy voting, you'll need to make sure that the amendment to your bylaws to comply with ONCA includes in the bylaw itself that your members can vote by proxy. I typically encourage clients to not allow for proxy voting. If a nonprofit allows for it, there are specific requirements in ONCA that have to be followed in terms of the format of the proxy. So just be mindful that you're going to have to take a look at the ONCA regulation and follow the rules that are set out there about what has to be on your proxy form for it to be considered valid. A corporation may provide in its bylaws for voting by mail or by telephonic or electronic means, in addition to or instead of voting by proxy. So these are other means of voting that would address concerns about members not being able to vote if they cannot be present at the meeting without the administrative challenges that come along with proxy voting. ONCA allows for there to be more than one class of members in a nonprofit. Some of your organizations may be set up so that only the directors are the members of the nonprofit. So that would be an example of a one class of membership corporation. Other nonprofits are set up so that anyone can be a member of the nonprofit, and they all have a vote at member meetings. This is also a one-class membership corporation. If you have this type of governance structure, you should give consideration to setting out a specific number of members that need to be present for quorum of your member meetings. Many organizations run into problems when they have quorum for a members meeting that is a majority of the members being present, and then have hundreds of members in their organization. So if you had 200 members and the quorum for a members meeting was a majority, then you'd have to have 101 members show up. If you are a nonprofit that can have 101 members show up to your AGM, kudos to you. Because most of my clients struggle to be able to meet the quorum requirements in their bylaws. So give some thought to putting in a specific number that you can easily meet as the quorum for your members' meetings. This way, you're not going to run into situations where you're trying to have your annual meeting, but you can't because you can't hit quorum. Another option for membership is to have one class of members with voting rights. For example, your directors that are members, and then another class of members that do not have voting rights. So for example, the general membership. Such a structure is of benefit to a nonprofit that wants a broader membership, but wants to restrict governance to the directors. So any limitations in the rights for your members have to be set out in your articles of incorporation or your articles of amendment. So if you do want to have more than one membership class, or you already have more than one membership class, you need to file articles of amendment, and you'll need to include the rights of that type of membership. So really the most important one is whether they have the right to attend, participate, and vote at the members' meetings. And again, your conditions or qualifications for being a member of the nonprofit, those would be set out in your bylaws. So the rights of membership are set out in the articles, and then any qualifications to be a member of each class of membership would be set out in the bylaws. Under ONCA, directors are able to discipline members or terminate their memberships. This has to be provided for in the articles or the bylaws of a nonprofit for directors to have this authority. So discipline or termination of a member must be done only in good faith, and it has to be conducted in a fair and reasonable manner. Members must be given at least 15 days notice of any disciplinary action or termination, and provided the reasons why it is being recommended by the directors. The member must be provided an opportunity to be heard before a discipline or a termination decision is made by the board, and they can be heard either orally or in writing. But you want to set this out, or you have to set this out in your bylaws if you want to have the board have the right to cancel or terminate the membership of a member. So under ONCA, members have been provided considerable rights that can impact the operation of the nonprofit. Members can nominate a director from the floor at an annual meeting. However, you can put in the bylaws procedures for requiring members to provide advance notice of any planned nominations. Members are also able to requisition a meeting of the members. Members holding at least 10% of the vote can requisition a meeting of the members. So if the board receives such a requisition, then they have to call a meeting within 21 days of receipt of that requisition, failing which the members themselves can call the meeting. The members are able to consider any business that is set out in the requisition, barring some exceptions that are provided for in the Act. And those exceptions are really related to like not being able to bring a personal grievance against a nonprofit, or bringing a matter before the members that does not relate to the affairs of the nonprofit. A proposal can be brought forth by a single member of the nonprofit for discussion at the annual meeting. The proposal can include changes to the bylaws, which, as we've mentioned, is the nonprofit's rulebook for governance. The board has to put the proposal on the annual meeting agenda, or the member can appeal to the court for relief. So it's not an option of the board if you receive a proposal from a member. It's something that absolutely has to be addressed. The notice of the meeting is to include a statement in support of the proposal by the member if requested. Members are entitled to vote on a sale, lease, or exchange of all or substantially all of the property of the nonprofit, other than in the ordinary course of its activities. Members are entitled to vote on certain fundamental corporate matters, including the filing of articles of amendment, changing the purposes of the nonprofit, amalgamating with another nonprofit, and liquidation or dissolution of the nonprofit. Members have considerable rights to access some of the corporate records and the financial statements of the nonprofit. They can examine and receive extracts from the minutes of meetings or resolutions of the members or of any committee of the members. They can see the register of directors and officers, as well as the register of ownership interest of the nonprofit. So these are corporate documents that you should have in your nonprofit's minute book. So again, that was the register of directors, the register of officers, and then any ownership interest in real property that the nonprofit holds. They can also have a copy of the membership list, provided that the member submits a statutory declaration that will only be used for certain purposes. So they can't get a copy of your membership list to, send some kind of promotional material for their occupation. They can only have access to the membership list if they provide a declaration that, they're only going to be contacting members in regards to nonprofit business. Members are able to remove directors from the board. This is one thing that I really want to flag. A lot of my clients have bylaws that provide the other directors of the board are the ones that have the right to remove a director. This is in contravention of ONCA. It is members that have the right to remove a director. They are the ones that elect the director, so they have the right to remove them. So voting members are able to remove a director by ordinary resolution. That's also something that I've seen having to be changed in bylaws. Some bylaws require a special resolution, so like a 2/3 majority vote in order to remove a director. ONCA only requires a majority of the members vote in favor of removal. So just double check that in your bylaws. That's something that you may need to amend. So I'm not going to go into great detail about the remedies that are available under ONCA for members, but they are able to bring a lawsuit on behalf of the corporation. And they're also able to ask the court to order the nonprofit to do something or to refrain from doing something. So some considerable rights of the members have been provided in ONCA. They're, very clearly the government has indicated that the members do have membership governance authority. Many people are of the view that it's the directors that have all the governance power when it comes to both nonprofit and for-profit organizations, although in that case it would be the shareholders. But really it's the members that have considerable governance power. They're the ones that choose who the directors are. I mean, it's less of an issue if you have a closed membership, so your only members are your directors. But if you have an organization where The membership is not restricted to only your directors. You need to be very mindful of the rights that members have under ONCA, because they certainly have the ability to address any governance issues that they see with the organization. So I want to make sure that you are aware of the Ontario Business Registry. The Ontario Business Registry allows businesses and not-for-profit corporations to complete over 90 transactions online, including registering, incorporating, and updating their information. The OBR is available 24/7 outside of scheduled maintenance. So if you make changes to your corporate governance that require articles of amendment to be filed, such as going to a range of directors instead of a fixed number, you can file the articles through the Ontario Business Registry. Corporations that were incorporated in Ontario automatically had an online profile in the OBR created. So even if you've never used the OBR before, you do have a profile that is available to you. The other document that is filed through the OBR is your annual return. This is a document that a lot of nonprofits are aware that needs to be filed. So this is not a tax-related document. So a lot of my clients are like, oh yes, we file our return annually, our accountant looks after that. So this is not an income tax return. All Ontario nonprofits are required to file an annual return as ordered by the Corporations Information Act. So nothing to do with tax. You have to file your annual return within 6 months of the end of your fiscal year. The annual return sets out information like the nonprofit's address, email address, and identifies the current directors of the nonprofit. Even if there are no changes for that year, your board stays the exact same, you have the same registered office address, you still have to file the annual return. So make sure that you file these. Failure to file an annual return can result in the government dissolving your nonprofit. So it's very important that you make sure you're up to date with filing your annual returns. I assisted one client with their ONCA compliance review, and we had to file 23 years worth of annual returns in order to bring them into compliance. And they're not alone. It's very rare that I have had any client that I've assisted with their ONCA transition where we're not having to file some annual return. So turn your minds to whether or not this is being filed. If you're a director, ask your CEO or your ED if they have been filed. And if not, then you want to make sure that you are giving instructions to them to get those filed.
Alicia, we have a question in the chat.
Okay, go ahead.
So with regards to signed consent within 10 days of being elected as a director, is there a
Yep.
specific document that is considered signed consent? Or if a new director signs a code of conduct and NDA, does that suffice?
No, so you would want to include that they are consenting to being a member of the board of directors. And the reason that the consent is required is the directors owe a fiduciary duty to the nonprofit when they come on to the board. So there are obviously obligations and duties that they hold to the nonprofit, but there's also the potential for personal liabilities to that director. So that's why there needs to be an actual consent. If they're signing an NDA and a code of conduct, I mean, you can include in there like one term, literally just add a clause to that document saying, I consent to being a member of the board of directors of X organization. I understand that I owe a fiduciary duty to the nonprofit. So literally, you just want to document that they understand what obligation they hold to the corporation. So that's why just having a code of conduct signed and the NDA wouldn't be enough. It has to be a consent to serve in the capacity of a director of the board. Okay, thank you for that question. Okay, so I want to deal now with some practical tips in terms of conducting your ONCA compliance review. So step one in your review is to collect and review the relevant corporate documents. The documents you want to look at are your letters patent and supplementary letters patent, or depending on when your organization was incorporated, it may be articles of incorporation and amendment that you're looking at. You'll want to review your current bylaws and any amendments that have been made to those. And also the minutes of your annual meetings for the last several years, as well as policies related to the governance of your nonprofit. And the reason that I recommend that you look at your annual meeting minutes is to make sure that you are actually following your bylaws at your annual meetings. One common issue that I see is that at an annual meeting, the members are electing not just the directors, but they are electing the officers as well. So they are electing the president of the nonprofit, not just a person to serve as a director. Under ONCA, the members would elect the director, and then the directors amongst themselves would appoint officers. So if you're going to have your members electing the officers, then you'll want to make sure that that process is reflected in your bylaws. So that's why I say look at your annual general meeting minutes just to see what the process is, and make sure that your bylaws are reflecting how your organization is being governed. The next thing that you want to do, or really at the same time that you're doing your document review, would be to request your nonprofit's company key. To access your online profile in the OBR, you need to have a company key. This is a confidential passcode that allows you to make filings and other changes to your nonprofit's account through the OBR. If you do not have a company key, you can request it through Service Ontario. If your nonprofit has an email address registered, then the company key will be sent to that email address. If there isn't an email address, then it will be sent to the mailing address by letter mail registered for the nonprofit. So if you aren't sure what information is registered with the government for your nonprofit, so for example, if you haven't filed your annual return in several years, it may be that you've moved your head office and it's the old address that the ministry has on file. You're going to want to make sure that you have the ability to get the company key, or before you request it, you need to call Service Ontario and make arrangements with the government to make sure that it's being sent to an address where you're actually going to be able to receive the company key. As mentioned, that's the way that you get access to the online portal, the OBR, through which you file everything with the government. So it's very important that you make sure the company key is going to be received by the organization. If you're not sure what information is registered with the government, you can request a corporate profile report, and it will show you all of the currently received, or the current received information from the government about your nonprofit. It's important that you don't use someone's personal email address as the association's registered email address. This is the email address through which the ministry communicates with the nonprofit. If that person were to depart the organization, then your nonprofit no longer has access to these communications. So it's recommended that you use a generic email address that several people have access to, so that it's always monitored. So, and you can make something up like, president at, name of nonprofit or at general or gmail.com. So just using a Gmail address and a generic email that will be available to several people will just ensure that continuity, so you don't lose your ability to receive communications from the ministry. So you'll want to next go through, give thought to what is the best governance structure and process to have for your nonprofit. So things that you'll want to consider: who will your members be? What are the conditions for membership? What membership rights does each class of membership have? How can directors and members vote? So are there going to be proxies? How many directors should your organization have? Should there be a range of directors? How long are the directors' terms? Should there be a cap on them? Do you want to have, or do you want the board to have the ability to discipline a member or terminate their membership? So you want to give some thought in terms of the corporate governance. So the old Ontario Corporations Act that applied to nonprofits contained very few rules, unlike ONCA. It's often easier to just start from scratch and try to amend your old bylaw. Be mindful that it isn't only the bylaws that need to be prepared as part of this process. Articles of amendment will likely need to be prepared as well. You'll also have resolutions that have to be drafted to be passed by the board and the members approving the changes to the bylaws, amongst other things. An ONCA compliant proxy will need to be prepared if you're going to permit proxy voting. And as mentioned, a director consent will need to be prepared and signed by all of your current directors, as well as any newly elected directors going forward. You will next need to approve your new documents. So ONCA compliance cannot be done only by the board. Member approval is needed for the changes. If the articles of amendment include a change in the number of directors, it requires a special resolution of the members to make that change. A special resolution, as mentioned, is passed by an approval of 2/3 of the vote cast. Some of the changes in the bylaws would also require a special resolution by the members for approval. You then need to file the articles of amendment through the OBR. Your bylaws do not have to be filed. Only articles of amendments need to be filed. The ministry will issue a certificate of amendment once they've been filed. If your organization has multiple letters patent and supplementary letters patent, and now you have articles of amendment, you may want to consider also filing articles of restatement in which all of the former constating documents are combined into one, just to make it a little bit easier for yourself. If your organization is a registered charity, then you would need to send a copy of your bylaws to the CRA. The CRA does not have to approve the bylaws. They just want to have a copy on file of your current bylaws. You may also want to consider whether training is required for the board or your staff and volunteers on the new bylaws. You should diarize a review of the bylaws for every 3 years to make sure that they accurately reflect how your organization is being governed. And you'll want to make sure that you diarize filing the annual return for your nonprofit so that you don't become non-compliant with the Corporations Information Act. Because as mentioned, the ministry does have the ability to dissolve your nonprofit for not filing an annual return. So on this last slide, I've included some resources that may be of assistance to you in your ONCA compliance review. So I've included the address for the Ontario Business Registry, also the address for Nonprofit Law Ontario. They have a lot of very helpful information about transitioning into compliance with ONCA. They also have a bylaw builder as a feature on their website. There's the guide to the Non-for-Profit Corporations Act, which is a government publication. And then the Not-for-Profit Corporations Act Standard Organizational Bylaw, which is also prepared by the government. For those organizations that don't comply with with ONCA, so they haven't done anything, they haven't changed their bylaw. As of October 19, they will be deemed to be following the standard organizational bylaw written by the government. So just be mindful, if you are not done by that deadline, that's the bylaw that is going to be governing your organization. Does anybody have any other questions?
I've got one more here.
Okay.
Can the bylaws provide that a certain person or group has the right to appoint the directors of a nonprofit, or do members always have to elect directors?
Members always have to elect the directors. And that's done at the annual meeting. So it's not something that you can, there's often like a nominating committee that will put forward recommendations for people to fill the role of director. But you still have to go through the process of presenting that slate of candidates to the members, and the members have to approve who you approve those candidates. And there's no acclamation under ONCA. So even if nobody you have just the right number of people that have indicated interest in being directors, you still have to go through the process of the members electing them. They're not just acclaimed. You have to present the slate of candidates to the members. It may be that the members agree with 2 of the candidates recommended by your nomination committee, but they don't like the third one. So 2 of your 3 candidates may be elected by your members, but the third may not, which is why you can't have an acclamation. Any others?
And I've got another one.
Okay.
Actually, a couple more.
Yeah.
So first, do you have any suggestions as to who could assist organizations with undertaking this review for ONCA readiness?
I can, would be my first suggestion. And then if if hiring a lawyer to assist with the process isn't feasible for your nonprofit, I would strongly recommend that you check out the nonprofit Ontario law website. I'll just flip back so that the email address, or sorry, the web address is available there. So Nonprofit Law Ontario. It's a great resource for nonprofits. As mentioned, it has a bylaw builder that you can use to help in this process. So that would be my first, if having a lawyer assist isn't an option, then the Nonprofit Law Ontario. You might check out their website. It's a great resource. And then also check with Pro Bono Law Ontario. So it's an organization that will assist individuals and other corporations, nonprofits with legal issues. It's how it works is it's law students that are working on the file under the supervision of a licensed lawyer. But that might be another option for you if you're not able to retain counsel.
Okay, next question. Is there a minimum number for quorum required by ONCA?
So quorum for a directors meeting is just the majority of the directors. For a members meeting, no. There's no minimum set out in ONCA. It just indicates that your quorum has to be set out in your bylaws. By default, it will be the majority of your members, which, as I discussed, can become problematic if you have a very large membership. So I strongly recommend putting in a specific number. I had one client where we put 4. 4 members have to be present in order to have to meet quorum for a members meeting. And obviously they didn't have hundreds and hundreds of members, but they even struggled to get all of their directors at meetings. So we just put down 4 individuals need to be present to hit quorum for a members meeting.
Okay, and the last question I see here. You mentioned directors are often the only members of the corporation. Is that a good practice? And who are the directors then accountable to?
So the directors are always going to be accountable to the corporation. Their fiduciary duty requires them to act in the best interest of the corporation. It really depends. A lawyer answer. It depends. Most nonprofits are set up so that your membership is limited to the directors. To me, in terms of ease of governance of the nonprofit, yes, a closed membership is a good option. As I mentioned, what you can do if you want to have, like members of the public involved, you can set up a membership class, a second membership class, where they can attend and participate in your general meetings, but they don't have voting rights. So you would have an annual meeting that they can come and speak to. You can present your reports to the members, but in terms of actual voting privileges, that's limited to just the members that are directors. So as I said, most of my clients are set up to have closed memberships where it's just the directors.
If the bylaws are silent as to who chairs a meeting of the members, who has the right to chair the meeting?
So if you don't have, well, you have to have a chair. There has to be a chair. ONCA requires that the board appoint a chair. So after your your annual meeting, where the members have elected the directors for the board for that term, then the board has to appoint a chair. And then that chair is responsible for presiding at the board meetings and the member meetings. If the chair is unavailable, then ONCA has that the members would be able to choose a a chair amongst themselves. You can put in the bylaws, and typically what is in them would be you have your chair, who's also your president, and then you have a vice president who will assume the duties of the chair in their absence. So if your chair slash president wasn't able to attend a members meeting, then your vice president would be the chair for the meeting. Any other questions, Dylan?
That looks to be it.
Okay, thank you very much, everybody, for attending today. If you have any questions, please feel free to reach out. As mentioned, I am available to assist in your ONCA compliance review process, but happy to answer any questions that you might have as you go through the process. And again, check out that Nonprofit Law Ontario resource. It's got a lot of great information, the bylaw builder, or you could refer to the Ontario government's standard organizational bylaw as well as a starting point in your process. So thank you very much for attending, and have a great afternoon or a great day.